Getting a green card is not the finish line. It can be taken away, and under the current administration, enforcement is a priority. Green card holders are not exempt from that. Just because you have permanent residency does not mean it cannot be taken away. In this video, I'm going to walk through the most common ways green card holders lose their permanent residency, what immigration officials are looking for right now, and what you should be doing to protect yourself. And remember that if you're still working towards your green card through an EB-1A or a national interest waiver, you can request a free case evaluation using the link below to find out if your profile is strong enough to file. The easiest way to lose your green card is by spending too much time outside the US and inadvertently abandoning your permanent residency. Professionals get employment opportunities abroad and don't think to alert USCIS. So here's a rule of thumb. Any single trip under 6 months is generally fine. Once a trip passes 6 months, expect extra scrutiny at re-entry. Once a trip passes 12 months without a re-entry permit, immigration authorities may treat the absence as an automatic abandonment. DHS now uses an AI-based tracking system. Every entry and exit is recorded and attached to your immigration record. The whole point of permanent residency is not just to be able to live in the United States, is making the United States your actual home. So if you're eligible, consider applying for a re-entry permit before leaving. It allows you to remain outside the United States for up to 2 years without inadvertently abandoning your residency. It does not guarantee re-entry, but it protects against abandonment accusations. So try to spend at least 9 to 10 months every year physically inside the United States. This is also important if one day you want to apply to become a naturalized U.S. citizen. Even if every trip is under 6 months, immigration can still question whether the United States is actually your home. Officers are looking whether your actual life is here, not just whether your trips were short enough. So having a residential lease, a real fixed address, a lease, a mortgage, or living with family where you constantly receive your mail, having financial ties to the United States, an active U.S. bank account, regular transactions, U.S. credit cards, filing taxes every year as a resident, having a job in the United States, U.S.-based business, or staying on payroll during extended trips. Also having family in the United States. If your spouse and children are physically living here, school-age children should be enrolled in U.S. schools. Have ties to your community, your driver's license, club memberships, religious involvement, etc. Before you spend a long time outside the U.S., make sure your ties are clear and easy to prove. Because once it looks like you have shifted your life abroad, immigration officials can use this as a reason to take your residency away. Criminal activity can land you not only in jail, but in removal proceedings. There's immigration consequence to a criminal conviction. Even things like DWIs have huge consequences. You go out to dinner, you have one too many drinks, the worst happens. That can have serious immigration consequences, as do crimes involving moral turpitude, theft, shoplifting, fraud, domestic violence, assault. Makes you deportable even if within the first 5 years of residency and the offense carries a possible sentence of 1 year or more. It does not matter what sentence the judge gave. What matters is the maximum possible penalty. Now let's talk about aggravated felonies. Murder, rape, drug trafficking, robbery, mandatory detention, almost no waivers are available. Congress is actively considering a bill that would make even one DUI a deportable offense for non-citizens. Remember, immigration law does not require a conviction, a guilty plea, no contest plea. Time served, probation, or certain diversion programs can still count. If you're a green card holder and have gotten arrested or charged with anything, even something you think is small, talk to an immigration lawyer before you accept any plea deal. Not filing taxes, not paying debts, not paying child support may not lose the green card right away, but it will definitely hurt when applying for citizenship. Permanent residents are required to file Form 1040 every year and report worldwide income, even if you lived or earned money abroad. Skipping a year, filing incorrectly, or claiming non-resident status for tax purposes can be used as evidence that you do not consider the U.S. your home. Tax evasion of $10,000 or more can be classified as an aggravated felony, meaning deportation is possible even after years of legal residency. So make sure you file your taxes every year. If years are missing, file them before submitting anything to immigration. If money is owed, set up an IRS payment plan and stay current. Keep your IRS transcripts. that is the first thing an officer may look for. One of the most serious immigration violations, and some people do it without realizing what a big offense it is, and it can happen in everyday situations. Checking the U.S. citizen box on Form I-9, registering to vote or actually voting, mistakenly applying for federal student loans as a U.S. citizen, trying to get a U.S. passport, using someone else's birth certificate or passport. Under current law, it does not matter if you were confused, pressured, or did not understand the form. Even an unintentional claim can count. The consequences are tremendous. You can face immediate removal proceedings, permanent inadmissibility, possible criminal charges with very few exceptions, and no way to fix later. If you ever see a box that says U.S. citizen on a form, avoid it. Slow down. People who get a green card through marriage get a 2-year conditional green card. When it comes time to apply for the 10-year permanent residency card, many file the wrong benefit request, either filing by themselves or with a non-attorney. The green card lapses, expires, and USCIS may deny the case. The Form I-751 must be filed during the 90-day window before the conditional green card expires. Filing even 1 day late can trigger removal proceedings, especially now under the current administration. And there's no grace period unless extraordinary circumstances apply, like a serious medical emergency, being abroad when the window opened, incorrect instructions from USCIS, or being a victim of abuse or extreme cruelty, divorce, or death of a spouse. This is one deadline you do not want to miss. Now, a lot of green card holders watching this video are professionals who obtained their residency through an EB-1A or a national interest waiver, or are still working toward that. If you are in the process of building your case and you want to understand whether your profile is strong enough to file, you can request a free case evaluation using the link below. My team and I will review your background and help you determine the most strategic next step. Some people who divorce before their 2-year green card expires apply for a 10-year green card, but don't know that they have to prove the marriage was bona fide. If they can't prove it, USCIS denies a 10-year green card and sends you a notice to appear in immigration court. And that's exactly what's happening right now. People are being placed in removal proceedings and getting a notice to appear after USCIS denies their 10-year green card application. Once you get a notice to appear, your case is no longer in USCIS jurisdiction. You are in immigration court, in an adversarial process, fighting for your permanent residency. The biggest mistake is that people think it's bad for immigration to admit that they are divorced. So they stay married on paper and apply for the 10-year green card as if they are still married. Immigration finds out, and now they are charged with misrepresentation and fraud. Staying married on paper to avoid immigration consequences makes the situation significantly worse. There is a legal mechanism that allows you to petition for your 10-year green card even if you got divorced. It is done all the time and cases get approved all the time, but you have to do it right. Giving false, incomplete, or misleading information to immigration, USCIS defines this much more broadly than most people think. This includes hiding a previous deportation, leaving out past immigration violations, lying about employment history, submitting documents that don't match earlier filings. DHS's biometric and data management system can now connect travel history, visa records, tax records, driver's license data, and every past immigration filing in seconds. Some accidental mistakes may not be seen as misrepresentation, but the issue is when USCIS believes the mistake was deliberate and affected the outcome. Misrepresentation is one of the hardest issues to fix. Very limited waivers. Most people don't qualify. If you notice an old mistake, talk to an immigration attorney before submitting anything new. Correcting an old error the wrong way can make matters much worse. Green card holders are legally required to notify USCIS within 10 days every time they move. Not the post office, not their bank, USCIS. This rule was not heavily enforced historically, but that has changed under the current administration. So file Form AR-11 within 10 days of every move. It can be done online. Save the confirmation page every time. Filing a change of address with USPS does not update USCIS. Most immigration mail is not forwarded by the post office at all. Thousands of people choose this option every year, sometimes without realizing the full consequences. Signing a Form I-407 officially states you no longer want to be a permanent resident. Once submitted, the green card is gone. No appeal and cannot be undone. Common reasons include moving abroad permanently, wanting to avoid US tax obligations, or preferring to visit on a tourist visa instead. The moment you formally abandon your status, you become a foreign national again, and you may need a visa just to visit the US. This also affects your spouse and your children who got their green cards through you. Only abandon your green card if you are completely sure you no longer want to live in the United States as a permanent resident, because once you give it up, you cannot get it back automatically. So permanent residency is not the finish line. It requires active management, especially in the current enforcement environment. And if you are wondering why your green card timeline keeps shifting or why USCIS processing times seem unpredictable right now, I have a video that explains exactly what is happening and what it means for your case. You can watch it right here.